This is Professor Porter. Today we're talking about crafting an evidence essay. I do a lot of talking about evidence in general, how the rules work, how they play out in court, specifically directing this to writing an evidence essay for the bar for a final exam. First thing to think about, you usually talk about law school courses in terms of issue spotting and separating out by issues, and I think that's what you do in most courses. The issues in an evidence course are items of evidence. So your first dividing line, your Roman numeral, big Roman numeral dividing points in an essay, is going to be what items of evidence are at issue. They're either looking backwards, these are items of evidence that were introduced at trial, you got to say which ones were proper, which ones were improper, or it's just telling you what everyone plans to do at trial, and you say these are the items of evidence that a proponent would try to get in. So oftentimes we make the mistake of, we talk about the plaintiff or prosecution's case in chief, and then the defense and defendant's case in chief. Where we are in the case is important for some rules of evidence, but not important for organizing our essay. The main thing you need to think about, you can write on top of this prosecution's case in chief, but the dividing lines that we need to know are what are the items of evidence, and start with big Roman numerals. These are the items of evidence at issue. Next, for me, think about it as the next dividing line, the capital letters are what objections would the opponent have to that item of evidence. So if the AAA evidence is the first item of evidence at issue, I like these topic sentences right below the first topic sentence you see. As counsel for the plaintiff, opponent, they are the opponent, plaintiff would raise the following three objections: relevant subsequent remedial measures under 407 and 403. You're putting it out there, and you can actually get credit for that sentence because you are issue spotting to bring up the three objections that are at issue. And sometimes in the rubric, the professor might only have points for one or maybe two of these, but you can figure out how to write them and get to them and really try to talk about the objections that are at issue, the rules that are at issue. And you can see how it goes. You should be talking about how the opponent would argue first. We put it on the opponent to raise objections and argue objections. How the proponent would respond, who was trying to introduce this evidence, how would they respond, and how would the trial court rule? So the opponent's in black typeset, the proponent's response is in blue typeset, and then the trial court, how they would rule on each objection, is in red typeset. And I would go through each one of those objections so we know in the end, how does the court rule on each individual objection, and therefore how do they rule on admitting the evidence or excluding it. If I drill down on one of these objections, you can see, it turns into IRAC. People think that evidence or writing an essay for evidence is different than all your other law school exams, that it somehow doesn't involve IRAC. No, the issue is this evidence, the item of evidence that you've identified, is it admissible? Is it ultimately admissible? The issue is, what should the court do with it? The rule is going to be an individual rule under each one of these objections. So relevance under 401, it has a rule, and it essentially is spelled out in 401. So you would incorporate that rule, separate out that rule in presenting the relevance objection by the opponent in this case. And your analysis really comes in here. The opponent would argue in support of that objection, and make sure you have a because in there. Analysis means that you're explaining, using the facts that are offered in the problem, you're saying because these specific facts. And then it flips back to the proponent side. As to relevance, they would respond, looking at these factors because, and using the facts from the problem. That's how we get into essentially analyzing each rule under evidence and getting into the analysis. The important thing to think of here, and I think we miss it on this sometimes, if you set out that there's three viable objections to an item of evidence, right here we have a different item of evidence, this initiative protocol evidence, but we've identified those same three objections: relevance, subsequent remedial measures, 403. No matter how I come out on relevance, I would do that whole analysis. I would say, here's what the opponent would say, here's how the proponent would respond, here's what the trial court would rule. Even if I conclude that the trial court would sustain a relevance objection, and ultimately, if any of them are sustained, if any of the three objections are sustained, then this evidence is going to be excluded. But if I do that, and I've identified three different objections, I get to all of them. That's what I do as a law student in an essay. So you see the sentence, assuming that the court finds it relevant, even if that differs from my analysis up above, I move to the next objection of 407. Assuming arguendo, even if, assuming that the court goes a different way on this objection. Those are the types of clauses, those are the type of sentences that allow you to offer the rule and analysis under each of your 3 objections that you've outlined above. And here you see, I would just respond the same way. I make sure that I can set out the rule once, and in that rule, which is often going to come from the Federal Rules of Evidence, and here Rule 407, I'm going to argue which ones of those factors apply to me. And if you think about it, 407 is going to come down for what is the purpose for which the proponent is offering it. If I'm objecting under 407, I'm going to say it's for a bad purpose. I'm going to say it's to prove liability or something like that. In the rule offers acceptable purposes. So I could here instead for specialty would respond, no. As the proponent, I'm going to offer this evidence, or I'm trying to offer this evidence for an acceptable purpose, like knowledge or notice, something like that. You see here again, now I've gone through both of my first 2, both relevance and 407. I'm getting to the last one. Doesn't matter how I came out on relevance, doesn't matter how I came out on subsequent remedial measures. I get to my 403 objection that I outlined in the beginning would be one of the viable objections. Assuming the court finds, that we'll get all the way here. And I talk about my rule under 403, especially if it's identifying the danger of unfair prejudice. And then I'd make sure I'd go to the response. One's going to say that the balancing test favors exclusion. The other one's going to say that this is not the time for the court to exercise its discretion under 403, that the balancing test just doesn't come out in the way where unfair prejudice substantially outweighs the probative effect of such evidence. And so the conclusion of the IRAC, the C in IRAC, is I'm going to talk about what the trial court would do. For each individual objection, I'm going to say the trial court would overrule or sustain the objection depending on the analysis that I set out above against the rule that I set out above. And by the end of this item of evidence, by the end of all of Roman numeral 1, I'm ultimately going to explain if the court's going to admit or exclude the evidence. And we set up 3 hurdles as the opponent: relevant, subsequent remedial measures, 403. The evidence has to clear all 3 hurdles. So you have to essentially overrule all 3 objections to get to a place where, as the court, you're saying the conclusion would be to admit that evidence, or that if you're looking back on it, that it was properly admitted. This is a little bit controversial, but I don't think it hurts most people, especially in the bar context. You can always include, especially in the days where we're using our computer to take exams and take bar exams, right? If you go back at the end of all your analysis and include a topic sentence that applies to the whole essay, in this essay, I've identified the following 5 items of evidence. So if you talk about the items of evidence, you've essentially set out in a topic sentence. It costs you 1 sentence. Here are the 5 items of evidence I'm going to be talking about below. That you can include another sentence or another part of a sentence that says, in discussion of these 5, I'm going to talk about the following objections. Because again, if you're doing it at the end, you've already talked about, I'm going to address relevance and hearsay and subsequent remedial measures under 407 and authentication and expert opinions and witnesses, so on. And so character evidence. I'm going to go through all the ones I'm going to discuss below. You can get points for this. You can get points for identifying the items of evidence. Those are your issues. You can get points for identifying what objections are at issue in the essay. And I think, for a little bonus coverage, again, it costs you 1 extra sentence to put it at the beginning of this essay. You can say, ultimately, the court either should have or should admit item of evidence 1, exclude 2, so on and so forth. You actually give the results of how you come out. I think if you're a bar grader, or if you're a professor reading this shows some awareness if your first 3 sentences say, here's all the items of issue, all the items of evidence I will talk about. Here's all the evidentiary rules and back and forth that I'll talk about. And ultimately, here's the result. Here's the conclusions for each item of evidence, see below. I think it can get you some points, and it doesn't cost you much time in an essay. Hope this helps.